All rise. Court of Appeal, Linden Fourth, Fifth District of the State of Florida is now in session. The Honorable Harvey L. J., Chief Judge, presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, State of Florida, and this honorable court. Please be seated.
Afternoon. This is the afternoon session of the 5th DCA. We feel at home here in Duval County because we are all residents of Duval County. So that all fits, but we want to thank again the Fourth Circuit for having us, and what a wonderful courtroom. And we are utilizing, I believe, the video equipment, the audio equipment of this courtroom, which has really enhanced our ability to be able to stream all of this in real time. Please remember that we are in session. This is a real courtroom and a real oral argument. So if everyone would be mindful of that, turn off your cell phones, any electronic devices that may interrupt the proceedings. That said, I believe, Mr. Russell, we're ready for the first case of the afternoon. Pine Grove ADG Holdings versus Roberts Diesel Service. That's case number 241759. Mr. Russell, would you like to reserve any time for rebuttal?
5 minutes, please.
Right, so noted. You may proceed.
Thank you. I was going to stand up here and first say, welcome home, Your Honors, but it sounds like you are home. Welcome to Jacksonville. Instead, I'll just say good afternoon. Appreciate this. With me is the principal of Pine Grove, the appellant in this matter. It's Ken Atlas. And we represent the appellant, Nicole Busey and Lanny Russell, Pine Grove. The appellant, Pine Grove, was the buyer in a large failed real estate transaction, and Roberts Diesel was the seller of that tract of land that did not sell. Hopefully, during this argument, I can refer to Pine Grove as it is the seller and the owner of the land. Pine Grove is the buyer, and the seller of the land would be Roberts Diesel. That should be clearer for everybody, including me.
I think on behalf of the panel, I think that makes a lot of sense, Mr. Russell. So please proceed in that regard.
Thank you, sir. The trial judge concluded that the seller did not want to close this real estate transaction. The buyer did not want to close the real estate. I'm confused myself. Buyer did not want to close this transaction. And that's just not a very plausible conclusion here. The buyer was to purchase from the seller of a large tract of land, that tract of land for $10 million. There was a simultaneous closing between the buyer and a third party at which the buyer would receive.
And I don't mean to split hairs here, but my review of the record, I didn't read the trial court judges saying that anybody wanted to do one thing or wanted to do another thing. My understanding is the trial judge simply found that the buyer failed to close within the correct timelines. Wanted may be a bit of an overstatement, no?
I'm trying to recall, because I thought she said the word want actually in the transcript recently. It didn't want to close the transaction.
Well, that's why I'm asking for a correction, because I may have overlooked that, but wanted to me sounded like an overstatement. If I'm wrong, then yes, please do correct me.
I would be surprised, Your Honor. I'm questioning it, but it was very much the understanding that the fight was over who didn't want to close the transaction. And if it was just they didn't close, somebody had to cause that. It doesn't just happen accidentally. And it was much more than an accident here. But back to why I was saying the idea that the buyer, Pine Grove, wouldn't close this transaction is not plausible, is because of the structure of the transaction. Pine Grove was buying a large tract of land for $10 million. Simultaneously with that purchase of the tract of land, the buyer would receive from a third party an additional $2 million for the property. And as the third party, the home builder developer built out the 797 homes. An additional $10,000 would be paid to Kendale upon the sale of each lot. So,
Mr. Russell, as you know about perhaps this judge, procedural issues always intrigue me, and I see first up among your issues on appeal is a procedural issue, talking about the transcript being the basis of the reasons behind the motion for summary judgment, and or the granting of the motion for summary judgment, and I want to make sure I understand that. You would agree with me that the court directing the attention of the parties to the transcript is permissible. You would agree with that?
I would.
So as I understand your argument, you're saying that there is either ambiguity or outright contradiction in the transcript, and therefore that would undermine the basis of saying on the record what the basis of the summary judgment is. Did I say that rightly?
Yes, I think that's as the rule says it itself. It does go on in the comments, though, to say that the judge is obliged to prepare the order. And I take obliged to mean the judge should do it. Obliged could be satisfied with very specific directions. But if you looked at the transcript, it was an hour-long or so hearing, and a lot of back and forth, and a lot of conversation with the judge. She was very active during the hearing. Very active with me particularly, and
Help me again, and I missed the last, you said obliged to what? The
I'm
comments
trying to read it, it's right in the comment, the judge is obliged to prepare the order, is what the comment says. And it says the rule must be strictly followed. And I'm familiar, I've seen it most of my 40 years, the judge telling one of the parties to prepare the order. But in this matter, I think with the new rule, and given the manner in which the hearing went forward, it was back and forth. And the judge made lots of statements, some of which never appeared in the order, and some of which may have. But there was also...
As I read the, and I'm just looking at the rule, I mean, the text of the rule, this is 1510A. The court shall state on the record the reasons for granting or denying the motion. I don't know how you could say it on the record any better than saying it on the record, Mr. Russell.
Down a little bit farther into the comments is where the obliged word is, Your Honor.
Well, and thank you for the comments, Mr. Russell. I mean, I'm more concerned, as you would probably imagine, with the text of the rule. And as I did a jet tour through some of the cases, it looked like every case I saw said that the court had the option of either saying it on the record or capturing it in the written order. Now, are you familiar with a band of cases? Maybe I didn't find. I looked at 8 or 9 of them. I could recite them if you want to see them. But I found last night that said either way was a good enough thing. Is there a case that says you've got to capture it in a written order, everything, the whole basis, the reason behind why you're granting summary judgment?
I read that into obliged, but that's me. It could be read differently. But in this case, the court didn't pause and state on the record why she was granting summary judgment. She talked some, and then at the end, she said, and I listed them in the brief, there was a number of them, 4 or 5 potential reasons she identified, but none of those were in the seller's summary judgment papers. They didn't make those arguments. They didn't have the evidence that supported those arguments, and they couldn't be supported by the judge herself. They just weren't there. And it's A through D and 1 and 2 of things that aren't in the record that she said in connection with, I believe, making a ruling at the end of the matter.
I did see you made some arguments in your briefing as well about certain issues that she granted dispositive relief on were not pleaded. Is that an argument you're making here today in front of us? Pleading issues that were not properly put on notice about what you were aware of might have been happening?
Yes, sir.
And if you could just elucidate those for us.
So find them. The, some of these actually were errors or not in the record. The judge determined that the list pendants, which caused the problem in this transaction when the sale was going to happen, was cured as a matter of law the moment the post-closing agreement was fully signed. And that's not accurate, Your Honor. The post-closing agreement didn't come into effect till it became operative. And it became operative when some property was purchased, went into the hands of the person, seller, and they satisfy, either one could satisfy the list pendants. They had to get rid of the list pendants. This post-closing agreement was fully signed, but the record's very clear. It was never funded. It never became operative. And one of the ways you can tell that, most of this is going on in the early part of the year, whatever year it was, in October and November. Well, the list pendants doesn't come off the record until December of the end of the year. And that's when the funding for the removal of the list pendants didn't come from the buyer, it came from the seller. So the list pendants did not immediately remove the list pendants. And that was one of the conditions of the, not surprising conditions of the purchase and sale agreement, that the title be marketable. And as we show in our papers, I believe, there's nothing much clearer than a list pendants makes the title unmarketable. And the other finding of the trial court that I don't believe was argued in their papers at all, the buyer agreed not to close on August 15th, 2022 because buyers signed the standstill agreement. Please look at the standstill agreement. The standstill agreement says words of one syllable. This standstill agreement does not affect the purchase and sale agreement. And the buyer, we'll see, this is a contested point, but the buyer through Mr. Atlee justified absolutely. They were prepared.
If a standstill agreement,
Sir?
if a standstill agreement read broadly doesn't affect a purchase and sale agreement, then what is a standstill agreement?
In this case, it had a particular purpose. They can be broader, as you just pointed out, that the parties not sell the property, the seller, and that the buyer not sue the seller while they tried to work it out. That was the purpose. Two things. A standstill agreement can be terminated by both parties if they wanted to. They're the only parties to the agreement. So if the seller says, I don't want the standstill agreement, I'll sell you the property today, 2 days early. And the buyer says, fine by me, I'll buy the property from you 2 days early. No breach of the agreement because both parties to it have agreed to move forward.
So the standstill agreement then is an illusory agreement? Because
I'm
you
sorry,
can't do
forgive
that
me, Your Honor.
anyways.
I'm just not hearing you very well.
If the purchase and sale agreement is in place, he can't sell the property to somebody else anyways. If
Right.
that's the only thing he's agreeing to do, then you're saying that the standstill agreement was just an illusory agreement. If it doesn't affect the purchase and sale agreement, then it's nothing.
I didn't hear your question, Your Honor. I don't know if you turn your microphone up. I just can't hear you, sir.
Your position is that the purchase and sale agreement, the only thing you were requiring from the buyer was not to sell the property. They're already under that obligation by the purchase and sale agreement. So if the standstill agreement doesn't affect the purchase and sale agreement, then you're telling me that the standstill agreement was a nullity, that it was an illusory agreement, that it didn't mean anything. And I don't think we can read it that way.
Seller not agreed. The contract had been performed. He argued that it had been breached by not closing, and if it's breached by the other party, then in this case, the seller would be free to sell it. To stop that potential, they agreed to a short standstill while they, as they said, tried to work it out. And it went on to say it didn't affect the purchase and sale. But if both of them agree, it's not going to cause any issue. They agreed, they didn't terminate the standstill agreement.
Did they?
And no, because they never got to the point of selling the property yet.
Which in a very roundabout way brings me back to our initial question. If holding if putting the purchase and sales agreement on hold is not implicit in a standstill agreement, then what is a standstill agreement?
I think it is implicit in this agreement. My only point was, there are two parties to the standstill. And as with any agreement, the parties can say, we don't want that agreement anymore, we both agree to terminate. And free to do what they want with the property, sell it to each other, or sell it to a third person. The other argument was made, I don't remember if the judge made this or the seller, because she made a lot of them herself. If you look at the transcript, you'll see that, is that section 3B of the purchase and sale agreement required the buyer to close within 10 days of the standstill agreement expiring. And that's not accurate. The buyer had to close the sale within 10 days of the lis pendens being dissolved, not the standstill agreement. Very clear in the purchase and sale agreement, can't have something that makes it unarguable, and the lis pendens was on the property for many, many months more after that point in time. And the seller offered to sell the property on two other later dates, November 10th, 2022, and December 31st. And at those two dates, the lis pendens was still on the property. And that was a condition precedent to the buyer being obligated to buy the property, that it be marketable. And it's about as clear in real estate as anything is in real estate. Lis pendens, properties with lis pendens are not marketable. That's why we put them in the title report.
Beyond defending a court case that may have arisen on notice of the lis pendens, what exactly was buyer expected to do?
So I'm terribly sorry, Your Honor. I have the head here. If I can step up here.
Certainly.
What exactly was buyer expected to do? Besides defend any subsequent court case that could have arisen after the notice of the lis pendens. To remove the lis pendens, they basically have to say, no, you're wrong, we're going to defend our case. If that's all they do, what obligation have they not met?
Well, it turned out that wasn't the case here. It took the escrowing of $150,000 and the payment of $40,000 to get the holder of the easement to remove it from the property. The buyer had no idea what it would take to get that easement removed. They never offered.
When a buyer,
Sure.
any buyer receives the lis pendens, what are they obligated to do at that point?
Were they obligated?
What would have they been obligated to do under this PSA?
They wanted to use the area where the lis pendens was to the exclusion of the holder of the lis pendens. They couldn't do that. They couldn't build a road where the lis pendens was. They couldn't sell the property to a third party who got lis pendens, the same reason they didn't want to.
What are you saying they should have done to cure the lis pendens?
Buyer?
No, what should have the seller done to cure the lis pendens that they did not do?
The seller was obligated under the agreement to make the title marketable. They should have gone to the buyer and done what the buyer asked for. They could have done it for, and the record is, they said had several opportunities to do it, and they chose not to. And they clearly could have done it for what it cost afterwards to do it, which was the $150,000 escrow.
So your position is buyer's obligation was to show Global their underbelly and say you can have whatever you want to make this go away.
They don't need to say that. They could go offer them a price and see what they said. They ultimately.
Are they obligated to go and offer them a price? As simply saying, no, we're going to defend our position here, enough.
The answer was, you can't obligate the holder of the easement to go remove it. If that happens, this is a transaction at the buyer's option of the large tract of land, doesn't go forward, doesn't have to go forward. The buyer could waive that provision and take the property with the lis pendens and own the property. The buyer didn't want to do that. The buyer wanted the seller to do its obligation and go make the title marketable and get rid of the lis pendens.
Proceed.
Mr. Russell, you are well into your rebuttal time because most of that was eaten up by questions from the court. I will give you 2 more minutes on your rebuttal and also give the appellees 2 more minutes as well if they're so inclined. But you can continue on, but we're about 3:30 left on your rebuttal now.
I got it. The comment to Rule 1.510, Your Honor, is comment D, and the wording of it, not Lanny's wording of it, is the court is obliged to make the order provided for by paragraph D of this rule. The entire rule is mandatory. The order must be entered. The order must specify the facts which are not controverted. And the judge never identified what facts were not controverted and what she based her ruling on, and it's not in the final judgment either. The facts are not identified, which is clearly required by the rule. And you can tell that from the party's brief, Your Honor.
It's clearly set forth in the commentary. Now, I didn't see it in the cases and I don't see it in the rule, but I hear you. Thank you for reciting that for me, Mr. Russell.
Oh, I know what you're saying. If you look at the party's brief as a pair and look at what they're saying, it's fairly clear that the parties are guessing at why the court did what it did. There's no specific directive. This application of the law, it's just go prepare an order in accordance with the remarks on the record. And that hearing went on for at least an hour. And it was a lot of back and forth and a lot of inconsistencies within the discussion. The judge also, I didn't know quite what to make of this, as we were ending the hearing, and she was talking to me directly, she said, "We are not going to see the facts the same way. I get that, but it's just, and thank you for indulging the manner in which I have these hearings. It helps me to say all this out loud. It helps me to go back and forth with you guys on the facts. And in the effort to get it right, I hopefully did." And that sounds a lot to me like somebody who's resolving factual issues, not somebody who's looking for uncontroverted issues, arguing back and forth to the point where she thinks she's found the fact by the discussion. And that's not an uncontroverted fact necessarily. It could be, but that sounds like somebody who did a bench trial. It doesn't sound like a judge who just did a summary judgment hearing. The other point I was going to make, real quick, I have 42 seconds, is in the transcript, I didn't write on the page, I had a quote, I think. The judge said that Ken Attlee was at the closing. Ken Attlee was not at the closing. He was in Colorado. He had, Friday before the closing, from Colorado, signed all of the transaction documents before a notary and had sent them to the closing agent, those documents. They were at the closing agent's office on August the 12th and wired to the closing agent the $10 million that was necessary to consummate the transaction. And no closing happened. The declaration of Ken Attlee, which is in the record, says, "Pine Grove was ready, willing, and able to close the sale of the 0 Garden Street property on August 15th, 2022. And what I just described is somebody ready to close the transaction."
All right, Mr. Russell, you have run through your rebuttal time. So if you want to close it in about 15 seconds, we'll hear you, and then we'll hear from the other side.
The thing I would ask of this court, and it's a tedious bit, and perhaps if you don't read the whole briefs, each of the briefs, it comes out, I think, more dramatically in the last 20 pages of the brief. And what comes out in that is the defendant in this case, is not getting the benefit of an independent arbiter. He's getting the problem of somebody who from the bench is allocating positions that are the seller's, positions the seller didn't itself allocate or put in the record. And this is not the first time this has happened.
Thank you, Mr. Russell. On behalf of the appellee, Robert Diesel Service.
Good afternoon, Your Honors, and welcome to Duval County. My client's courtroom as well, Mr. Taylor and his daughter. I can try to answer what I think some of the questions are.
Can I,
Go ahead.
can I just ask one question up front? I'd like you to address one of Mr. Russell's last points. The order that we have in front of us says for the reasons set forth in the hearing. And then we have a pretty long transcript of that hearing. Can you tell me exactly what basis, if we were to find for you, what would we be affirming?
Okay, the summary judgment is it states, first of all, that the parties did not expect an August 15th closing because there's an August 10 email which proposed that the parties delay any closing and enter into a standstill agreement. And then the judge said, well, after that point, there was a certain amount of time where the contract here required 10 days after the resolution of a lis pendens to close. The court then said the appellant here, Pine Grove, cured the lis pendens because they entered into a binding written agreement with Global Signal, which would resolve the lis pendens at any closing. And that agreement, she read it very carefully. It says it does not have a termination date. It goes on and on. She also said that there were several points where after there was a bunch of title problems, things happened, and then after the standstill agreement, after they were trying to work things out, my client then offered to close. In October, they demanded closing by November 16th, which is 3 weeks later. Then when the appellant demanded more time, they said, we need more time than that.
It may not be particularly relevant to whether there was error below or not, but I'm curious if your position is those later offers to close, were those just uncontracted negotiations? Had the PSA expired already pursuant to the paragraph 3B clause when they gave what I think you characterize as a conditional response to your inability to cure?
Okay, well,
In other words,
definitely,
are you arguing there is a PSA in place, or are you arguing there is no PSA in place?
we were arguing there was a PSA in place. If you look at the October demand, it says demand for closing. And it's addressed to Mr. Russell by me. And I said, hey, there's a contract, we demand closing. We want to close by November 16th, okay? Now, the second demand was in an email, which is in the record, and I can find it, but it is, that was something that is, there's a whole proposal to sign a separate document that would extend the contract to December 31st. But the email, the cover page says, you have to close by December 31st. We need you to close, okay? Now, in all these things in the motions for a hearing, Mr. Russell brought up these several issues and actually filed various things in his briefs to the appellate court saying, I'm sorry, to the lower court saying, Judge Deering, look at this proposed contract that they said, that didn't give us enough time, et cetera, or something like that. So that's why we're bringing it up now. But definitely in the summary judgment motion, we had an affidavit of Robert Taylor, the principal of Roberts Diesel, saying, hey, we offered to close. We gave him 3 weeks notice to close in November, and we gave him 6 weeks notice to close December 31st. And the judge was very clear on that. She said, well, why didn't you close, Mr. Russell? What happened? Mr. Russell's response at the hearing and also to the response to the summary judgment was, well, we needed more time to obtain financing. And then getting back, did I answer your question? Hope so. But anyway, getting back to the issue of the August 15th closing. There's an email on August 10th from Coulter, which is copied to everyone. It says, Eric, I spoke to my client after you and I spoke. Coulter will be ready, willing, and able to close on the south parcel on the 15th, but is open to discussing alternatives, including purchasing the neighboring parcel to the west instead of the north part. In any event, Coulter is open to delaying the closing and entering into a 2-week standstill agreement to see if we can come to mutually agreeable terms. Putting that email out there, after that email, there is no other reference in the record. There's no demand, there's no notice of anything saying, oh, by the way, despite the August 10 email, appellant is now demanding closing on August 15th. There's nothing at all about something like, we're gonna close before 4:30 on August 15th. And 180 degrees opposite, there was like a fork in the road. There was a proposal to either close or to enter into standstill agreement. Parties took the fork in the road. We go down and sign the standstill agreement. Everyone agreed to that. It's all there. Now, we didn't address, we did say that in our summary judgment motion. We said things were going along, there was this issue. We cited in the summary judgment motion, we cited the provision of the contract 3B, which requires a closing within 10 days of the resolution of the title dispute. We also stated in our summary judgment motion that the appellant admitted that the title issue was cured by the post-closing title agreement. It's in the summary judgment motion, and that's, I think, paragraph, it's in page 13 of our answer brief. What sets it out. But getting back to this issue, the parties never expected any closing on August 15th, and the key thing that would show you that is that the appellant never pled that as a breach of contract. Okay, the appellant in its breach of contract claim doesn't say anything about an August 15th closing. Okay, so when we have a summary judgment motion under the new summary judgment standard, we can prove the non-existence of plaintiff. We don't have the burden of proof. We can prove the non-existence of a genuine issue of material fact. The non-existence was that we didn't breach the contract. We did whatever we could do to close this contract. When we filed our motion for summary judgment, we filed various evidences and various things like that.
What did you understand your obligations to be when the Liz Pendants made the sale or the property unmarketable? What did you understand your obligations to be to cure that?
Well, we understood there was some issue, and the record does contain a letter from me to Global Signal saying, what do you want to resolve this? Okay, and that's stated in our brief. And the response from Global Signal is, we're not going to tell you. We're dealing with the appellant. Okay, the appellant had gone and done this thing. When it eventually came out as to what Global Signal actually wanted, they wanted a bunch of things that were non-monetary things that had to be agreed to by the appellant and Coulter. For example, they wanted a change in the easement terms. They wanted access 24/7 to this property. And the idea of this property is there's a dirt road, it's like a farm out there.
No, in short, they wanted things that weren't agreeable to you.
No, they were agreeable to us. We could not agree on behalf of the appellant to resolve those things.
Do you assert that there's nothing on your part beyond reaching out to them and saying, what can we do? And assumedly negotiating in good faith if they gave you a reasonable answer? What did you appellant you were supposed to do?
We were there to do whatever we needed to. However, it's undisputed that appellant Pinesgrove never demanded of us to pay any money. They never said, you have to pay $47,000, you have to pay $150,000. Nobody said of us anything. Additionally, before the closing in March of 2022, Pinegrove's principal went and met with Global Signal. And they talked about the development and everything like that. At that point, Global Signal didn't demand anything, okay? And we were saying, well, look, Global Signal, you're gonna get a paved access, you're gonna get this new development. So everyone thought they were happy with what was going on, okay? It was only right before the closing that they started demanding things. And then at the closing, if you look at what was going on in the appellant's testimony, we said, what was the issue with the closing? Was it that we had to pay any money? He says, no. Regardless of whatever was in the complaint, these things about the Global Signal Liz Pendants and everything else, or Pinegrove's duty to pay money, all we needed was more time. Okay, that was all we needed was more time to close.
And so that I understand correctly, you say that the defect was cured at which point?
we agree with the trial court that once this signed binding agreement, the post-closing tri-party agreement was signed by Appellant, Coulter, and Global Signal, that was it. It was cured.
So they had 10 days at that point to close the transaction.
Correct, but we put this in our summary judgment motion. The parties in August 10 agreed to delay the closing, which is what this email says. And there's nothing after that email saying, oh, wait a second, we're going to go back to August 15th. So
Now-
go ahead.
And correct me if I'm wrong, this may have actually been a more appropriate question for opponent, but my reading of your opponent's analysis of the cure date would be that your deadline to close would be 10 days after closing. Is that correct?
No, I don't think so.
If you have to close within 10 days and it's not cured until closing, then wouldn't your deadline be 10 days after closing?
Well, the idea was that if you read the post-closing tri-party agreement carefully, it says, and I've got it right here, it says that upon closing, this is paragraph 5, it's record 732. On or before the date of the closing, GSA 4, that's Global Signal cell phone tower company, agrees to provide for the dismissal of the action, provide for the discharge of the list pendants, and provide such documentation and assurances by the title company that the closing will happen. So they're saying at or before the closing, Global Signal is going to release the lawsuit and the list pendants. So it doesn't have a delay. Does that answer your question?
Kind of.
Okay. And then going beyond that, before I forget too much, the action proceeded. Robert Cecil then got the action dismissed and the list pendants resolved. Okay, it was wiped out. The action was dismissed, list pendants was discharged. And that notice was provided to appellant on January 24th. Although it's not in our summary judgment motion, I agree with that part. But this was raised by the appellant in their response to our summary judgment motion. So Judge Deering then said, well, why didn't you close within 10 days of, if your argument is the list pendants was still there, so we didn't have to close, why didn't you close when it was gone in January 2024? And the answer was no answer. I think there was some statement about they needed 6 months or something to get the money back, but that was what the judge said. She particularly looked at the contract, and she said, well, the contract that Mr. Atlee, on behalf of Pine Grove, selected, which is undisputed about that provides for a certain amount of time. If he needed more time, it's too bad. I do think that the judge could not at all provide some kind of a denial of summary judgment based upon some August 15th closing. That was not pled. If we did that, then we'd have to file another summary judgment motion and do facts, and that would eviscerate the summary judgment rule, because you could never get to summary judgment. They could come into summary judgment and say, well, I want to raise this unpled issue, and then we'd never get to a summary judgment. Also, the appellant never moved to amend their complaint, and the appellant at the hearing, they never expressed any surprise, saying, I didn't understand Mr. Kohler's motion. They never moved to continue the summary judgment hearing. So they knew what was going on. I think our summary judgment motion clearly set out what we were saying. It talks about these things, and it talks about a demand for closing. There was a letter, and it says, pursuant to the contract, we demand closing. So we're saying the contract's still there. Can I answer any other questions? Okay. Another issue here is the appellant has raised a lot of issues in their cases about a Vermont Lakes case, okay? And the Vermont Lakes case says that if the seller seeks to avoid a contract for the sale of real property based on existence of title defects, then the buyer is not entitled to specific performance of the contract unless the buyer shows that the seller failed to exercise reasonable diligence in clearing the defects. And then reasonable diligence only requires the seller to act in good faith and appropriately in view of the circumstances. It does not require the seller to make extraordinary efforts or expenditures. The point of this case is that we are not saying in the summary judgment motion, I don't think the judge is saying that in the summary motion, that we could have just stopped what we were doing on July 28th and said, well, we're not going to sell you the property anymore, okay? Our good faith went beyond that. We entered into a standstill agreement. We agreed to delay the closing as requested by everyone. And then we said, all right, we'll give you more time. And when the buyer said in October, after we gave them 3 weeks, they said, we need more time. We gave them another 6 weeks until December 31st. And not only that, but if you're right about this issue of, it's kind of a settlement negotiation of this proposed deal that we're going to enter into, okay? But the point that is not a settlement negotiation is the cover facts on that, offer, the cover facts on the proposed amendment, okay? And this is, I refer to page 1131 of the record. This is a November 18 email from myself to Mr. Russell. I said, my client requires closing by 12/31/2022. And it also says, we'll give you a 45-day extension on the closing for an additional fee. So that is, that would extend the closing until February 15th, 2023. So we were bending over backwards to try to help them do their thing. And the answer from them was, no, it wasn't like, we'll show up or do something else. Another issue is that we addressed in our brief, if they wanted to say that we needed to pay something to Global Signal, they could have merely shown up at the closing and tendered the $7.5 million to buy the south parcel less $40,000. Okay, they never did that. In fact, if you look at the evidence, they weren't going to deduct any of the purchase price. They said, we're fine with what Global Signal wants. We don't care. Okay, so that goes back to our argument at summary judgment and now is that whatever they're saying that we breached, those were non-material breaches of contract. If there was something that we did wrong, it didn't cause any prejudice to the buyer. It didn't cause them any harm. And I asked Mr. Atley repeatedly at his deposition, what was the issue? Why didn't you close? His answer was, after August, we needed more time to re-verify permits. That's what he said. He didn't say anything about anything else, okay, and any of these other breaches of contract in the case. And that is not our issue because they agreed to extend the closing in August, okay? So if something was going on, they could have demanded a closing in August, but they didn't. They never pled that. There is some things about, we talked about the Corey, Your Honor, Mr. Judge Jay talked about the new standard for summary judgment. And there is some issues in their appellate brief that we have to do an extraordinary job of proving beyond reasonable doubt something. We don't have to do that. In Corey versus City of Tampa, it talks about that if you are the party without the burden of proof, which is what we are, if we come down and say your complaint cannot succeed, that you don't have any evidence showing that we breached the contract, then we win. Okay, so that's what we're arguing about here. And the judge is saying, basically no reasonable jury could say that you breached the contract. You offered them to close. You did what was required. And so I think at every point we did. I mean, our problem was, it wasn't a problem, but the appellant decided to go immediately to Global Signal, get this post-closing agreement hashed out and agreed to and signed. And under that agreement, that resolved the issue. So then the next thing that happens is there's a August 10 email saying, let's delay the closing and enter into a standstill agreement. Now the judge Deering did say, well, she finds the post-closing agreement or the standstill agreement delayed the closing. But I think if you look at all the facts around there, the August 10 email, that there's nothing after August 10, between August 10 and August 15th, demanding a closing, and the standstill agreement that we're performing, the parties have this agreement, regardless of whatever the the standstill agreement actually, talks about the contract. The parties agreed. I mean, they had an agreement, they had a meeting of the minds, and the exchange of emails shows that. I do think that Judge Deering let's look at what she did. She spent a lot of time, if you read the transcript, you can see that she really went over everything at issue in this case. She knew everything that was going on. She looked at all the agreements and everything else. The transcript is 115 pages. She spent a lot of time on this issue before the hearing, looking at everything. Okay. She said that in the transcript, well, I'm not going to consider some evidence because there's a little something a little unclear about. I'm sorry, there's nothing unclear, but the appellant had filed a motion for summary judgment at the same time and then withdrew it the morning of the March 16th. So there were certain documents that were filed in opposition to appellate's motion for summary judgment. She said, I'm not considering that because that's not part of the case. I then provided her a proposed order, and I think Ms. Russell objected to that. And so the judge said, well, I looked at this issue. She knew that she had to give a detailed summary judgment that would be able to be reviewed by the court. And that is what she did. She said the transcript is really good on what I found, and it was fine. And then we cited numerous cases in our answer brief. Including Simmons versus Public Health Trail 338 Southern 3rd 1057, stating that the transcripts of the two that it affirmed, even without a written order, saying that the transcripts of the two hearings showed the trial court stated its reason for granting summary judgment with sufficient specificity to allow appellate review. And this transcript is sufficient. It says, look, here it lays out the facts, and it says she's not finding that we exercise reasonable diligence and we don't have to convey the property at all. What she's saying is that after all this bad stuff happened, Robert Cecil said, let's go ahead and close, and there was no closing. And that the contract requires, once those title defects are resolved, that the contract must be closed within 10 days. Do I have another minute?
I think we're done, Mr. Kohler, but thank you for your time, and thank you both. I would ask the next lawyers to let everyone clear out. I'm also going to inquire of my marshal or someone else as to